and over to you. Okay.
Thank you. And you don't need me to restate who I am, right? We're just continuing. Okay. So I know you have other witnesses, and again, I will submit this for your review, but I do just want to, we talked about accountability. You've heard that. I don't need to drill that in anymore. I think you all see the issue with our current 18-year-olds, and then again, if we add 19-year-olds. Something that I heard in testimony last week, and I believe even yesterday, was a reference to sort of everything that falls outside of 5402A, which is our big 11 plus 3, quote, big offenses, that everything that falls out of that is, quote, low-level offenses. And I really want to underscore that that is not an accurate depiction of what offenses could and do wind up in family division for delinquencies. So I won't go all into this again. You all can review it, but the red column on viewers left, right, is our 5402, our big offenses. The column in the middle are our listed crimes. These are a combination of misdemeanors and felonies, but these fall out of our 502A cases. So these cases currently with raise the age for 18-year-olds, and if we move forward and have 19-year-olds, 19-year-olds alleged for these offenses are filed directly in family court. And then the misdemeanors absolutely stay in family court. The felonies may transfer back up to criminal court. And so, and just to break this down, between, these are some of the misdemeanors. You know, we talk a lot about simple assault or operating a vehicle without owner's consent, car theft, or retail theft. And yes, those are a number of the misdemeanors that we're seeing 18 and 19-year-olds commit. However, I do just want to point out, you know, a number of these misdemeanors are serious offenses, and that you victims of these crimes, everyone in this room, I think, can agree, and your community members can agree. I can assure you our department does not see these as low-level offenses. So these are the misdemeanors that must stay in family division. And again, just highlighting, these are felonies, again, that fall outside of that big 11 plus 3 that must be filed in family court and then may transfer up. And as you heard in the earlier testimony, that ping-ponging of starts in family court, and then if there's a motion to transfer it, time before that transfer hearing happens, the juvenile needs to show up for that transfer hearing. If they show up and it does go to criminal court, okay, now it's a criminal proceeding, but then there can be a motion for YO and it can go back down. And I just want you all to consider the time that is passing as that occurs. And that time matters for the person involved, the alleged offender, and it matters for the victim and the victim's family.
So before I go to Zach and then Angela, this question about that. So are the criteria then are different for the transfer from family court to criminal court when somebody goes in as a delinquent than it is for youthful offender for transferring from criminal court to family court? These are different criteria? Or should those criteria be the same so there's one determination? If you've transferred from family to criminal, you're not going back if you've gone through that motion practice.
It's worded slightly differently, but it's a similar idea. We talked about that last week as far as, you know, youthful offender consideration is the public safety first, and then if public safety can be met, then the ability for the juvenile to be rehabilitated, basically their amenability to that rehabilitation, and the resources available. Are there sufficient resources to help rehabilitate this child? I would need to pull up the transfer, but it's very similar. But what's happening is that the family division is holding the transfer hearing, and whether it goes up to criminal court. And then the criminal court would be holding the YO consideration hearing,
Okay,
my
it's
understanding.
different judges look at things differently.
And I do know, I have had YO consideration hearings in family court as well. So
Okay, so
Go
we'll
different.
we'll explore that a little bit.
but it is written slightly differently, and I'm Attorney Paul no doubt knows the transfer statute, probably has it memorized. So he could probably highlight that language better than I can, or I could pull the statute up.
And I understand from Judge Sone's testimony that this will be part of recommendations, perhaps when they come back in December of this year. Yeah, it was a bill that we passed last year that asked them to look at this kind of an issue. Zach, and then Andrew.
Thank you, Chair. Kim, if you can go back 2 slides, please.
The
Yes.
misdemeanors?
Yeah, looking here at the misdemeanors, one of the common things that we've heard in testimony both this week and last is the idea of escalation, in that, crime is, escalating in terms of severity. Is it the department's opinion that the misdemeanors listed here could potentially be precursors to the Big 14? Because I think of a very tragic domestic assault or sexual assault instance, oftentimes it potentially has the potential of escalating, if not resolved, to something quite severe in, I think of murder, in terms of domestic violence.
I would not feel comfortable presenting the department's opinion on that without more
Concrete
input.
data, sure.
Yeah.
And if you go to the next slide, I'm not as familiar with 3521 domestic terrorism. I mean, it sounds really serious. Can you give me, how is that defined to your understanding?
I would want to pull up the definitions.
Yeah, I'm just not
I
familiar with it. It sounds extremely serious to me. So I just think, to your point, those that might not think anything that falls outside the bounds of the Big 14 in terms of severity or seriousness. I mean, domestic terrorism seems to be probably at the top of the list in terms of concerns. And Representative Goodenow has definition for me, but
and to underscore that, I wanted to pull these out. These felonies that fall outside of the quote big offenses cause massive harm.
Yeah.
And we fully appreciate, and I heard this said multiple times yesterday, that, we're really trying to help these young adults, move forward, and we really want to serve them. And I want to remind everyone that there are young adults, 18, 19-year-olds, who are victims of these crimes and younger. And that we need to be thinking about them as well when looking at this. And we fully appreciate wanting to, again, help the folks alleged to have committed these crimes have a better future, but know that their actions have caused, if it is proven that they have committed those crimes, they have caused massive harm to individuals who will live the rest of their life, right, recovering from these actions.
And I just would add, just as an additional point on that, looking at the term domestic terrorism, it's defined as the cause of death or serious bodily injury to multiple persons, so death is a factor here, or threatening any civilian population with mass destruction. So it really is a very serious, although it falls outside the bounds of the Big 14, it's a really serious offense.
Well, and to highlight that if anyone is murdered, right, the first section, that would fall under murder, which would jump you up, but it's the threatening.
Mass destruction to a civilian population.
That part would fall outside.
Yeah.
So just noting that side.
Well, I just wanted to ask about first, 2 questions. So on the point you're making about the time elapsed, because of that potential ping pong motion practice business, is it fair to say that I don't I don't think that's a good thing. You know, I think we could and should improve that. But I mean, many felonies take multiple years to come to trial or not go to trial, but some kind of resolution. So is it fair to say that you can't just assume that because if we start in juvenile court, we're actually on a faster track to start out, right, in family division. Then there may be the delays because of the back and forth. But is it fair to say that even with those delays, that resolution, that timeline is not necessarily longer than going directly to criminal court?
Well, it would depend, because one scenario to think about is, so it's a felony that falls outside the big offenses. It has to be filed in family court. It's filed. Transfer hearing, best case, well, we'll say happens in 3 months, but may take 6 months, could take 12 months to have that completed. It goes over to criminal court, and that time period that's happened in family court, that doesn't sort of change where that now felony and criminal court goes into the lineup, right? The felony caseload for that court, they don't factor in, oh, this case has been 6 to 12 months.
Right.
Like it's a new criminal charge now up there in criminal division. It just joins the queue and is slotted in, just like any other charge that's come in. And then, so we run into the backlog issue that I know you all will be talking about tomorrow. I kind of lost track of what day it is. And so it's over in criminal court. And then if the motion for YO occurs, then we're holding, waiting for that YO hearing. And then it comes back. And then they still need to have, goes back YO, they still need to have the actual hearing on the merits. Like, do we have evidence that proves that this offense took place? That needs to happen. Then the disposition. So I couldn't say, right, that all of that would happen in, under 2 years versus if it was filed initially in criminal court and stayed in criminal court.
Right. We couldn't say either way.
We couldn't say either way. Yes.
So it's almost a moot point.
I think, well, the point on my end for this one, that if say the case goes back into, so it goes back, we're now a youthful offender. The person was 18 when we started this. Youthful offenders decided, now we're maybe 20. And then we have till 22. So if this is a felony from the list that I just showed, okay, now youthful offender, they have 2 years to work with this person. Maybe that's gonna work, maybe that won't, right? So that time piece becomes important for that ceiling in family court, for how long they have to work with them. That's one issue. The second issue, again, is that for these crimes that have a victim, the victim is waiting and waiting and waiting. And it's really difficult to say to a victim, because the alleged perpetrator is 18 or soon 19, this is going to family court and you need to wait. Oh, wait, we might be going to criminal, like having those conversations of where is this going to go? What's going to happen are really, really difficult conversations.
And I think that's what I'm trying to get at is that the criminal justice system is not set up to serve victims. And it seems like there's more potential, it won't always happen, but there is more potential to center victims in a juvenile proceeding. I mean, some of the felonies that were listed up there, we've just in the last few years, we've allowed those, domestic violence cases to go to restorative justice because many victims won't even come forward if they know that they're going to have to enter the criminal proceeding and will feel more of a sense of justice through a restorative practice. So your your points are very valid and important, and I just think there's more to the story.
And if I can just add one more thing to consider from the victim's point of view. For delinquencies, the rights of victims are different between delinquencies and youthful offender. And then even within delinquencies, the difference between if it's a listed offense or a non-listed offense, as far as how much involvement the victim has. So for a non-listed offense in delinquency, the victim can know about court dates, right? But can't attend any hearings until disposition. So waiting, forever long. And then they get to make their victim impact statement at the very end. And for the non-listed offenses, they can only stay in the hearing for their portion of giving the statement. That's different for listed offenses. And so their access to what's going on because of the confidentiality pieces is very limited. And that is something that can be very difficult for victims. There can be pros to your point of family court versus criminal court. But in criminal court, because it's public, the victims can be there at every hearing if they want to.
Yeah.
And that's just something to consider.
Yeah, there is a shorter timeline than delinquency proceedings though, right? But based on what we learned last week.
If it just stays as a
Right.
delinquency, more than likely. Yeah, but again, there are one-offs, but yeah, more than likely. Though an important thing to consider for criminal misdemeanors, depending on the county, you could have on arraignment day an offer resolve your case that day. So sometimes it's very quick. So moving on, because I know you have other folks, but again, wanted to highlight the seriousness, wanted to highlight the back and forth. And then something I heard yesterday that I just want to correct. You may be wondering, well, what about YO for these serious felonies? And one of the representatives asked, when we change to 19, is that going to impact YO at all? And I just want to point out that for these serious felonies that fall outside, again, of the big 11 plus 3, the state's attorney cannot direct file as YO. Okay, I believe it said yesterday, like, oh yes, these are serious felonies, well, you could just direct YO. And that is not accurate. So I just want to underscore that the state's attorney can direct file if that case could otherwise be filed in the criminal division. So when 19-year-olds are added to the juvenile jurisdiction, again, those felonies outside of the big offenses must be filed in family division. And there's not an option at that moment for the state's attorney to file that as a YO. Someone 20 years old with the same offense, the state's attorney has that ability to file it as YO because it could be otherwise filed in the criminal division. So I just wanted to highlight that because I think that was sort of being mentioned yesterday as like, well, don't worry about this with the big felonies. You can immediately go to YO, and that is not accurate. I believe. Yep. So for today, that is what we wanted to provide for you. Again, we believe you've heard the accountability piece, the frustration piece. And again, we just wanted to highlight, again, the seriousness of these offenses for you all when you're considering how to move forward. And that is all I have, unless you have other questions.
I appreciate it. Thank you. And
Thank you.
like I say, we will be taking this up again if there's some follow-up, I think, to our data that we asked before that.
Yes, and we'll have a little bit more time to be able to pull that together than a week. And yes, I have that written down, the follow-up. And if after your other witnesses, if you have other questions that come to mind, please just send them over to the department so that we can pull that together.
Thank you.
Thank you so much. Take care.
All right, Marshall Paul can join us.
All right. So thank you for having me. Good morning. I'm Marshall Paul, Deputy Defender General and Chief Juvenile Defender. And I want to start with a couple of things. First of all, I want to address what seems to be sort of the big actual legislative question that has sort of gelled so far in this conversation, which is about the expansion to age 19. And just right out of the gate, I want to make clear that our office's position is that we're not opposed to necessarily, we are not opposed to further delay of the expansion to age 19. We're disappointed that we're not in a position now where we're hearing everybody sort of enthusiastically saying we're ready to go forward to age 19, but we don't want to go forward in an environment where people feel unprepared and where expansion is essentially doomed to failure because there's people who are not ready for it to go forward. And we are disappointed that we're not in that place. We thought that we would be in that place by now, but we really don't think that's necessarily the fault of anybody here in Vermont. I mean, nobody could have foreseen when Raise the Age was first passed that a year and a half into it, we would go into a pandemic that would sort of blow up our judicial system as we knew it, and we'd still be recovering from that years later. And we are. So we understand that we're in sort of a unique place. And so while we're disappointed that there's, not a sense that among a lot of the stakeholders that they are ready to go forward with that expansion, we understand that. We understand where they're coming from, and we're not opposed to some delay. We're certainly not in favor, though, of repealing or eliminating the plan because it's a really good plan and it works. And that's what I want to talk about, first of all, is just how well Raise the Age actually works in the first place. Since Raise the Age went into effect, 18-year-olds have been treated the same way that we would treat 17-year-olds in Vermont, with one exception, which I'll get to, which is that 18-year-olds can be supervised for 1 year longer than we supervise 17-year-olds. 18-year-olds can be supervised to age 19 and a half. 17-year-olds can only be supervised to age 18 and a half. One of the things that's come up a lot in the conversations I've been hearing this morning and yesterday is this idea that there's not enough accountability in the juvenile system, and the idea that when people age out of the system, they can just sort of wait for that to happen and then there's no more accountability. I want to make a couple of points. First point is, in all of these discussions, we shouldn't just be focused on the juvenile justice system, because what we're talking about is we're talking about taking cases from the juvenile justice system and putting them into the criminal justice system. And so we really always have to be comparing the two. And the juvenile justice system does not have lengthy criminal sentences. That's not an option in juvenile court. That's the only thing as far as a measure of accountability that's not available in the juvenile court that is available in the criminal court. And there's a lot of things that are available in the juvenile court that are not available in the criminal court. So when I testified last week, I talked a little bit about the difference between a criminal sentencing and a juvenile disposition. And I think that that gets actually to the strength of juvenile court and why juvenile court is actually a better venue for a lot of the cases that we're talking about and a lot of the cases that people are concerned about than criminal court. This morning, Chief Burke testified about how in the criminal court system, the cases move, especially misdemeanor cases, which he was pointing out fairly cause significant harm to communities, But in the criminal court system, there's not an opportunity for victim impact statements, and it's a pretty cut and dry process. That's not true in the juvenile court system. In the juvenile court system, we do have victim impact statements in misdemeanor cases. And we don't have any sort of shortcuts through sentencing because we have a disposition. And the disposition in every case, misdemeanor, felony, no matter how serious, no matter how minor, requires some of the stuff that Chief Burke and others were talking about as far as accountability that's not present in the adult court system. So just by way of example, so the statute, here we go. The statute on disposition requires the court, when it's setting a disposition, to take into account the child's supervision, care, and rehabilitation, the protection of the community, accountability to victims and to the community for offenses committed, the development of competencies to enable the child to become a responsible and productive member of the community. And then it gives a list of things they can do to try to achieve those goals. Those goals are not present in the adult sentencing statutes. And that's why, as you heard from Attorney McManus, a lot of adult cases are resolved at arraignment. Now, when you resolve an adult case at arraignment, that in 99.9% of cases means we're resolving them for a fine-only resolution, meaning you walk in at arraignment, you say, the prosecutor says, if your client agrees to plead guilty to this offense, I'll give you a $300 fine and nothing further. You turn to your client, you say, do you want to have a $300 fine and never have to come back? Your client says yes, and you change your plea that day and you walk out of court, you never come back. Now, there may be something beneficial to that to the court system. It certainly makes the court system move faster. But when you're talking about what everybody's been talking about, this concern about escalation, about people starting with lower level offenses and escalating into higher level offenses, do you want somebody going into court getting a $300 fine and being sent on their way? Or do you want a disposition proceeding in which a skilled clinician is going to look at a kid, write a report that says, here's what this kid needs for services, for rehabilitation, and to ensure that they don't go on to commit more offenses. Here's what they need to do in order to be accountable to the victim and the community. Here's what we need to do in order to protect public safety. Writes this whole report up, submits it to the court. The court has to approve or disapprove of the plan. So there's actually a lot more accountability in a lot more of these cases in juvenile court than there is in criminal court. I will acknowledge that one piece of sort of like maximal accountability that doesn't exist in the juvenile court is the possibility of a lengthy incarcerative sentence. In juvenile court, you can't be sentenced to 15 years in prison. You can't be sentenced to anything like that. You can as a youthful offender. I think some of these discussions have conflated the concepts of youthful offender and juvenile proceedings. But in the juvenile court system, that is the one sort of piece of accountability that's not there. And that's why we have the provisions that allow any felony committed by a 16-year-old, 17-year-old, or 18-year-old to be transferred to the criminal court. Now, one of the things that came up, and I do agree it's a problem, is the ping pong problem. And this has been sort of a theme, as there's been this there's been problems identified that I actually agree are problems. I'm not here to say that we have no problems. I just think that the response to those problems being, we need to repeal this, is wrong, because a lot of these problems are actually really easy to solve. So, for example, to the extent that people have concerns that, we have people who go in as juveniles and there's not enough time in the juvenile court supervision process to provide that accountability. We are in the, even though everybody's sort of, sees the fact that Vermont raised the age of entry into the juvenile jurisdiction system by 1 year more than most other states have, we're still far in the minority as far as the age of extended jurisdiction. There's 34, 30, 38 states that, where their juvenile court system can supervise children for longer than our court can supervise children. Our court supervision ends at age 19 and a half, at least as of 2019. And I know that there's been more states that have expanded since then, but the last state by state survey I could see was 2019. And 34 states had age 20 as their age of juvenile jurisdiction. 2 states had jurisdiction to 22. 4 states had jurisdiction to age 24, and 4 states had jurisdiction, quote, for the full term of the disposition order. I asked, one of those states was Connecticut. I'm friends with one of the chief juvenile defender in Connecticut. I called her and asked what that meant. She said in practical terms, that means about age 25. It means that the court can actually set anything they want as the end of the age of supervision, but that Vermont's Department for Children and Families provides supervision services to age 25, so judges never order anything beyond age 25. But so just to begin with, there would be a change we could make that would address one of the concerns that's been raised many times and would put Vermont sort of more in line with what most jurisdictions are doing. The same with Attorney McManus raised the issue of people aging out of youthful offender jurisdiction while they have a pending youthful offender violation of probation. That's actually an issue that's been around for a bunch of years, and it's been decided differently. Like, she gave an example where the court dismissed it and said that we've lost jurisdiction. There's other courts that have ruled the opposite way, because there's case law from the adult probation context that says that regardless of when the term of probation ends, if a violation of probation is filed before the term of probation ends, then the court retains jurisdiction to hear that violation of probation even beyond the term of probation. We've been waiting for that issue to get decided by the Vermont Supreme Court for years, but nobody's appealing it. So we agree that's an issue. It's an issue of law that's undecided and is being decided differently by different courts. And at some point, somebody's going to appeal it to the Vermont Supreme Court and we'll get a firm answer on it. But again, it's just sort of one of these things where it's one problem that can be solved.
So should we be clarifying that in legislation?
We absolutely could. We could. There's no reason not to.
For the court?
There's no reason not to, but it is something in the criminal context. It's case law. It was not put into statute. It's been something that courts have interpreted that way. So we've always assumed that's the way that case law would develop in the juvenile courts, because that's the way it developed in the criminal courts. It just hasn't. I don't know why people haven't been appealing them, but people haven't been appealing them. And that's our people too. I mean, I've been calling our people saying, why did she not appeal that? And not always thrilled with the answer. So I do also want to talk about this sort of pull towards the adult court, this idea that we need to move these cases to the adult court. One of the things that's coming up a lot is speed. Everybody is disappointed with the speed of the juvenile courts. I am disappointed with the speed of the juvenile courts, but it is nothing compared to my disappointment with the speed of the criminal courts. Most of the cases that we're talking about are going to be juvenile misdemeanors. Most juvenile misdemeanors fall into the category of public order offenses. Juveniles commit disorderly conducts at a rate that far exceeds what adults commit. So it's those kinds of cases that make up the bulk of these cases. If those cases are transferred into the criminal court system, they are not going to be a priority. Criminal court is very focused right now on moving cases for people who are incarcerated and for people who have very serious felonies that have been pending a long time. I just last year wrapped up a criminal court case that had 13 counts, 2 of which were felonies, the rest of which were misdemeanors that had been pending for 6 years. And so that's where the criminal court backlog is at. The juvenile courts are working much faster. And there's a couple reasons for that. One is that during the pandemic, the criminal courts shut down. They ground to a halt. the proceedings stopped happening. In the juvenile courts, with the exception of some merits proceedings that were postponed till the end of the pandemic, most juvenile court proceedings kept happening. So we don't have as much of a backlog in the family division as they have in the criminal division, which means our cases move faster. They also move faster because they're designed to move faster. You heard about the timeframes that are set in statute last week. I'm not saying we adhere to those timeframes. We certainly don't, but we try. And that means that our cases move a lot faster. I have cases right now in juvenile court that are a year old, that are incredibly serious felonies that have gone through a process of transfer from the criminal court to the juvenile court and will probably be wrapped up in the juvenile court in 1 year. If that case was in criminal court, I have colleagues of mine sitting right next door to me who have very similar cases in the criminal court. They wouldn't even anticipate those cases going to trial for years and years and years. So from my perspective, one of the benefits of the juvenile court is the speed of it. And that's super important in juvenile court because we have studies that show that juvenile court is not effective if it's not fast. That if you take somebody, a young person who committed an offense, and you cite them out and say, here, we want you to show up for an arraignment in criminal court in 3 months. And then they show up for an arraignment and all they do at arraignment is say, okay, you're released on recognizance and now we're going to set a status conference in another 3 months and then a calendar call another 3 months after that. You're not taking advantage of that young mind's plasticity and addressing the issues while you still actually have the chance to make a difference. So the last thing I'll say, just because I want to make sure everybody else gets a chance to testify, is that I think the opening of Red Clover has been very important. We have been without an accessible, appropriate, staffed, secure youth facility in Vermont for several years since Woodside closed. Now that Red Clover is open, we have that. Our office obviously is very concerned and sort of on top of conditions issues and how programs are treating youth. And Red Clover so far has been an excellent program. We're really pleased with the staff there. We're really pleased with the programming there. The facility kind of sucks. It's a couple of old temporary buildings stuck together, surrounded by a fence. But other than that, and honestly, they've actually managed to do a lot with a pretty crappy building. And we're really pleased with that facility. And it gives us, it fills a need that we have, which is the top end of our high level of care. We have that need for what do we do when we have kids who are in such a state of crisis that they can't be safely kept in a non-secure placement. And we had some really horrific situations going on. And, it's always talked about from the perspective of the danger to DCF staff when they were staffing kids in hotels and spaces like that. And we agree with that. It was very dangerous for DCF staff. It's also very dangerous for the young people who were being staffed. It was not the right environment for them to be held in, and they were not being held by people who were trained in the right way. So we are really happy to see Red Clover open and to see it functioning so well. And we think that that is a really key part of making our juvenile justice system work. And I'm happy to take questions.
Any questions? Oddly, none.
Can I finish up with one thought? Because I thought that would come up and I'd answer it in a question, which is, there's another thing that's come up that I just want to acknowledge as a reality is that there are youth, small groups of youth who are not responsive to the juvenile or criminal justice system interventions. That's also always been true. That we've always had that problem. And that's not just true of the juvenile justice system. In fact, it's more often true and actually more sad when you see it in the criminal justice system. I have plenty of clients who are in the adult system who are doing what I call life on the installment plan. They are going in, coming out. Prison sentences are not a deterrent to them committing more offenses. That's something that's true of people who are hopeless. When you lose hope, you really, things like prison no longer become a deterrent to maladaptive behavior. So I don't think that moving cases to the criminal court system in any way solves that problem. There will always be an outlier pool of people who are not reached by the tools of the systems that we have. We should be trying to come up with ways to reach that outlier pool. I think that in Vermont, the places we have some real weaknesses that are causing us to miss some of that outlier pool are in our adolescent system of mental health care. I think is woefully inadequate. And a lot of the people that we see as sort of being the outliers that are not responsive to our system are actually not responsive because we basically don't have an adequate system of adolescent mental health care. And so that's what we're seeing. But I just wanted to make the point that that doesn't go away by moving cases to the criminal court system. In fact, it just becomes more sad because instead of it being people who aren't reached by the sort of age-appropriate, individualized interventions of the juvenile court system, they become people who aren't reached by the non-individualized, sort of more blunt instrument interventions of the criminal court system, which I think is harder to recover from.
Appreciate that. Appreciate
Thank you very much.
Yeah, thank you very much for that. Been very helpful. Susanna Davis, if you join us. And thank you for coming over. And
It's a pleasure, Mr. Chair. Thank you all for having me.
yes. If you identify yourself for the record and proceed, thank you.
Good morning, buenos dias. Yes, buenos dias. I'm Susanna Davis, Executive Director of Racial Equity for the state of Vermont. I'm going to make it official.
Oh, I don't have mine. Thank you for reminding me.
Right. Well, I'm not going to bore you with a whole lot of data and facts for two reasons. One, because you've already heard a lot from colleagues around government who have given you a lot of those data. And two, because we actually have data that we would like to see on this topic. And I'll share a little bit about some of the research questions our office has developed on this topic. Much like others who you have or will hear from on this topic, our Office of Racial Equity stance is rather simple. We also would support a measure, or support the implementation of Raise the Age, but are extremely nervous, hesitant, frustrated, and apprehensive about the current state of the system and whether it can actually support a successful implementation. We are, and I guess I'll pull back the curtain a little bit into what some of our internal discussions are like as an office, but I recall discussing this with our staff, and the sentence that I kept loudly uttering was, just say what it's going to take. Just say what it's going to take. So, okay. That's where we are as an office on this. We do share some concerns that our colleagues in DCF have. For example, the fact that a lot of the data we're using are partial data. This committee knows better than perhaps any other that now that the office has a division of racial justice statistics, we are acutely interested in really understanding qualitative and quantitative data, and we only have a limited subset of both. So we join our colleagues in being concerned about making sure that we are being data informed, and yet we still do know enough to be able to act. And we have for years, and that's why this has been a topic of discussion for years. We also do want to echo those concerns about lack of staffing. That's one of the many resource shortages that you all have been hearing about. It's tremendous, and it could, not to be dramatic, but it could really make or break the success of an initiative like this. The state, you all as a legislative body have gone to great lengths to craft policy that makes sense and is going to be correct for Vermont, for Vermont's young people. And we want to make sure that it not only doesn't fail, but actually can serve as inspiration for other states who are also considering these measures. Vermont likes to lead, and we want to do it well. I do note that bills like, or laws like Act 23 of 2023, I know in early iterations did contain provisions that would have provided additional social work staff support positions for DCF. Those provisions disappeared by the time that the final version of the bill then became an act. But those were some of the key opportunities that we could have used to support and to bolster the rollout that we're now perhaps thinking about. Within our office, we also had a number of our own concerns or things that we wanted to highlight. One of them is seasonality. I don't know if that's a word. Saying it. This is something that the Crime Research Group has also pointed out numerous times. So we appreciate their insight and their knowledge as well. And really just thinking about the ways in which the population we're talking about fluctuate into, out of, and alongside the system based on which reporting cycles we're using. So if we're reporting data using a fiscal year cycle and not a calendar year cycle, then we may be missing certain seasonal trends or other information that we could be using to learn how the population is actually operating and whether, if and when we get to implementation, if any changes in the numbers we're seeing may be due to that seasonality or to the actual implementation. So I wanted to lift that up. Again, I know you probably already heard that from Crime Research Group, but did want to make sure that we said that.
Thank you, Chair. Susanna, that's a really interesting point on the seasonality, because that is not something that has come up in testimony. What are the trends that you're extrapolating from that?
Honestly, we don't yet have enough information to be able to, but that is one of the things that we're very interested in diving deep into.
Yeah, I'd be curious to see that.
Yeah, I mean, I will say that there are certain things that we could probably reasonably assume are going to be the case. We know that in wintertime, people struggle with things like housing, mobility, generally finding shelter and stability with that. So those may be certain patterns that we might see replicated in this population. But again, for us, it's early to tell, but it's something that we're very interested in learning more about.
Interesting. Thank you.
Another item that we wanted to highlight is the consideration about housing for the older youth. So when we think about having mixed populations, and we've looked at some reporting out of places like New York, I know that it's not like New York, but we can still always learn from other jurisdictions, even if they're not exactly like ours. One of the things to think about is if we're going to be considering housing youth of a certain age band in the same kinds of facilities, at what point do we need to stratify oh man, it's weird for the ORE to say this, but segregate the different age groups within that cohort, right? Because we might consider, I don't know, 14 and 19-year-olds perhaps legally being considered in a certain way under the law, but perhaps housing them in facilities close to each other may not be appropriate. So just thinking about the logistics of doing that. I know that there have been reconsiderations and redesigns of the planning and the construction for facilities that we're talking about. So we're certainly not the most knowledgeable on that topic, but it is something we've seen out of other jurisdictions that we are going to want to make sure that Vermont is considering. I just quickly want to talk a little bit about some of the research questions that our Division of Racial Justice Statistics has developed over the course of this topic. Some of these are things that you may have gotten answers to. I know a couple of them were revealed in testimony as recently as, I think, yesterday afternoon. But one of the things that our division is going to be looking at is where are the data that are from partner agencies, like the Judiciary or DOC, that indicate that raise the age would or would not be overly burdensome to staff. We are an office of few doing the work of many, and so we really empathize and stand beside all of our colleagues, not just in state government, but also in non-government entities who are trying to do good work with few resources. So we really want to lift up the fact that there is a need for that, and that it should be thoughtfully considered how we're going to support that. So, but still, data that would help us understand the severity of that burden would be helpful. Are there data from any of the agencies, perhaps that we can glean outcomes of the initiative? One of the research questions that we did develop that was discussed in your testimony, I think yesterday, was the volume of unique 18 and 19-year-old cases who would become eligible. And I think you all heard that that number was somewhere around 152-ish in the 19-year-olds. Has funding been allocated to DCF to be able to do this work or update their systems to incorporate those new caseloads, right? And make sure that we don't have that patchwork of case management systems that we're trying to operate from. Whether lived experience has been considered, and what are the experiences from juveniles in the various aspects of the system, like youthful offender status, juvenile probation, et cetera. Again, I mean, we as an office aim to speak on behalf of communities across Vermont, but certainly can't speak fully for them, and would encourage the committee to continue diving deep into the experiences of people who are directly impacted. And I, it's a new year, and I suppose we're full of new possibilities because I can't believe I'm the one saying this, but have we considered a working group outside of legislative session to really deeply work toward alternative solutions to raise the age? If there is another pause again this year, and again, we are not urging another pause, but we're also cautious and not wanting to set ourselves up for failure as a state. So wherever this group lands, if we do not move toward implementation, then we would be really interested in seeing somebody tasked with the responsibility for generating some level of alternatives to this. It could be perhaps the RDAP, it could be some other group. But I think that I don't want to lose this thread. It was Deputy Defender Paul who said that this is good policy and we shouldn't necessarily throw it out. But so many people are waiting on us. And being able to continue turning this issue over and considering it from all angles, not just what was true at the time that this was originally passed, but also what's true today, is important. And so being able to understand what all of our options are, if that has changed, I think could also be useful. So those are some of the research questions our division is going to continue to look into. And if the committee is interested in exploring that, then we'd be grateful to assist. I think that's it from me. Thank you. I welcome any questions you might have.
I don't see any from other folks, but so I think we're going to want to dive in deeper on the work of the Division of Racial Justice Statistics, and we will try to have you in and your staff the next couple weeks, just to because you're going to go over the report that you submitted on the 15th of January. There was a lot there to unpack, and really want to unpack it with you. And you mentioned some of the things already today in context of juvenile justice, but more broadly.
Absolutely.
So we'll try to.
I missed that.
Yeah, it's on the reports. I don't know if it's posted on our webpage, but
It is.
Well, there we go. It's on top of it as usual. So Angela, go ahead.
Donna, when you say, I wanted to just make sure I'm understanding this one point specifically, when you say it would be really great, helpful to have more data regarding the severity of the burden. Are you talking about, and not that you said that exactly, those are sort of that's my paraphrasing, the burden on specifically DCF workers of adding 19-year-olds to their caseload, or more broadly, the burden on the many systems that support juvenile probation?
Both. But I think that if we're really putting a hyper focus on a department like DCF, we've got to be able to support them with what they need. And so really understanding what is being asked and being committed not just to the tangible, meaningful change we want to see in outcomes, but also to supporting whichever parts of state government are going to be responsible for making it happen. So yeah, we are always very interested in hearing from people, and not just in the executive branch, but also across the branches of state government. What don't you have? Like this is where we are. This is where justice is. Tell me what it's going to take to get us there. And I think at least having a clear understanding of what that gap is is going to help us have a realistic and meaningful conversation about resources.
So that, I guess my follow-up question to that is, and you sort of just answered it, like, what would you be looking for in terms of data? And it's more than just a number of 19-year-olds.
Mhm.
So yeah, I guess you just answered it. Like, tell me everything that's keeping you from reaching the goal, which is justice and
Correct.
rehabilitation.
Yeah, and I think oftentimes when I ask people about resourcing or what they need, I'm asking, I have to ask the question twice, because the first time we all have a tendency to say what is minimally required to technically get the thing done. So then you have to ask the second question, which is, what's it going to take to get it done comfortably, robustly, right? So can we do this job with, I don't know, 4 people? Sure, technically. But it's burdensome, backbreaking. You're going to have a high churn, and we may drop the ball a few times. What's it going to take to do it well? And that's a different question. And so that's a lot of that is going to come through our discussions with our colleagues in the other departments and the other agencies. Those data will likely take that form. But to the extent that there are other insights that we can glean on what it's going to take across state government to really make this happen and do it well, then we'd be interested.
Yeah. Okay. One more.
Yeah, go ahead.
You just, because what will it take to do it well? Very important question that I think assumes that there's a will and a desire to do it well. I'm not sure that's present right now. And so I think that's one of my frustrations, is that I think someone has known for years what it would take to do this well. And that we're asking in 2025 and still don't know the answer necessarily. I mean, we were given, I think, 5 points, a list of 5 things, I think, from DCF last session, of things that would have to be in place in order for them to feel comfortable moving forward. My sense is that was probably that first list you were talking about, to just get it done. But I'm very curious to know the answer to the second question, and to know and to hear it from. I just don't know who wants to do this. I can't figure that out. And that's a point of frustration.
Yeah, Barbara.
So interesting, because I was going to ask this question before you asked that. So one thing that is hard for us, and maybe you have a magic way or thought about it, and I just want to preface it by saying this has been an issue no matter who has been the governor. This is not about our current governor at all. I've been an advocate. And one thing that's been really clear, even in the 2 governors that have been governors while I've been a legislator, is department heads are not always free to say what they need because of whatever mandate they're getting from the boss, which I get, having been a boss, but not in government. But it's hard because it sounds like you're finding ways to get at those questions that we're not able to get at, of like, I mean, there's the question of if there's a desire to do it, but putting that aside, assuming people want to implement whatever the law is, it would just be great to figure out a way to not have people feel stifled and not have people feel like they're going against their boss. And as an advocate, there are times that commissioners have off the record said, I can't ask for this, but you're an advocate. And it sure would be great if you looked at, wink, wink, the ratio that other states are, like some little clue that gives an insight. But it's one of those things that I think keeps us from doing our best work, or even sometimes good work.
Yeah, that's definitely understandable. I will say that sometimes you get glimpses into those breadcrumbs. early bill drafts, for example, and then they kind of disappear. And I think in some ways, those are the way of folks saying what it's going to take. And so I think if we, as the askers of the question, once we ask the question, we're implying comprehensively what it's going to take. And I know that you all will as well. And then we also jointly have to create the commitment in ourselves to say, then let's do that. I also think that there are ways at getting at some of that information. Perhaps, again, we can look at examples from other jurisdictions and try to right size it to meet our state's demographic, legal, and economic profile as best we can. And that could also be a decent starting point. I know our office has had a few conversations or been in educational opportunities with representatives from other states who have done this. So I think that there's also insight to be gleaned from that.
Questions? Thank you very much for your testimony. Thank you very much. Appreciate it. Judge Davenport, if you could join us. And thank you for coming back. Yeah.
Pleasure, always. So just for the record, I'm Amy Davenport. I am a happily retired Superior Court judge.
You don't sound very retired though, as we keep on seeing you coming.
Well, that's because I have time to come, right? I also am was a former legislator before I became a judge, and I really appreciate so much having sat in this room for 6 years or so, except for a brief stint on Ways and Means. It wasn't nearly as interesting as this. I appreciate so much the difficult decisions that you all are asked to make. This is not easy stuff. So I'm here, though, on behalf of the Council for Equitable Youth Justice. I have been a member since I retired in 2015. And Council for Equitable Youth Justice, with respect to raise the age, or including 19-year-olds in the raise the age effort, because raise the age already exists, right? We have the 18-year-olds, we just don't have the 19-year-olds. And the Council for Equitable Youth Justice met recently, voted on this, and unequivocally supports extending the raise the age to 19-year-olds, as was originally decided by this body back in 2008, 18. Well, I got my years wrong, but that's one thing when you get to my age, those years start to really blend together. And we support it because the science supports it, because you all got it right that, the science of adolescent brain development supports basically 18 and 19-year-olds' brains are not all that much better developed than the 15, 16, and 17-year-olds. They tend to do the same kinds of impulsive behavior, engage in the same kinds of impulsive behavior, and have aren't really able to control that behavior well until, in some instances, people have said until 25 or 26 years old, before your brain is really able to cognitively make appropriate decisions, particularly when you get. And we see it particularly when you get where adolescents, get into a group where one adolescent says, let's go do this. And the rest of them say, oh, that's a good idea. And it's very hard for an adolescent to say, oh, no, I think that's a bad idea. Let me tell you why. That rarely happens. So the science is right. Also, I think the theory of, which we talked a lot about back when we did raise the age, of the risk, need, responsivity, the danger of putting young people, especially young people, in a system where they will be, where we over-respond, because it's going to tend to make them worse. So we support it. I think the council would have the same caveats that you've heard from the last two presenters about, is the timing right? And that's the real issue, is the timing right? Now, you as a legislature have gone back and looked at this issue after it was passed two different times prior to today, and this is the third time where the question is, when is the right time for the 19-year-olds to come into the system? And both of those prior times, I sat through quite a bit of testimony, particularly in the Senate. The response from DCF was, and the administration generally, was a resource problem, not a problem with the science, not a problem with, is this the right thing to do, but a resource problem. We don't have the right amount of people. We're having trouble hiring. That was huge after COVID. Who was going to predict COVID would happen right after this? So it was a resource issue. It's only this year for the first time that we're hearing, oh, maybe we should just repeal the legislation. That was not the response, a year ago or 2 years ago. So a couple of issues that I just want to comment on that have come up as I've listened to the testimony yesterday. I didn't get to hear all of it this morning, but one was about recidivism. I mentioned in my testimony before, and it's now up on your website, we did a recidivism study of the 18 and 19-year-olds who went through the criminal division prior to the raise the age for the 18-year-olds. And recidivism in this population is high. It's came out at close to 47%. That's not to say that the second crime they committed was a particularly bad crime. I think, as Marshall pointed out in his testimony, it could have been, a much less serious offense than the first offense. It could have been but recidivism is high for this age group, and it's not surprising. That all goes back to the brain science and making smart decisions, right? We don't yet know whether how well the 18-year-olds have done since raise the age, the ones that have gone through the family division. And we are only just at the point where we could even try to measure that because you need this 3-year window. But certainly, shouldn't we find that out before we repeal? Even if you postpone, shouldn't we find that out before we repeal? And I did glance through the study, the Loeffler study that was submitted to you all. I don't pretend to be an expert on recidivism. You would really need to get somebody from the crime research group come in and talk about how they do these studies. But I can tell you two things popped out at me right away. One is that their recidivism study in that was for a 5-year period. It's normally a 3-year period. But the second thing, which is much more troubling, is they based it on arraignment. If anybody was arraigned after they were initially arraigned, were they arraigned for another offense? My understanding of recidivism studies, as I said, I don't pretend to be an expert. Robin would be a much better person to have come talk to you about it, is that you look at dispositions, at convictions, because a lot of cases get thrown out for a whole variety of reasons. It's dismissal rates somewhere around 30%. So, it just using arraignments was troubling to me. I don't know why they decided to do that. With respect to resources, it does kind of seem like we've reached an impasse. It is the argument that was used last year, 2 years ago. But we're not talking about adding a lot of cases. If you look at the state as a whole, I did ask the court to run charges, and this is not people, this is charges, from FY24, which would have ended on July on June 30th, 24. And felon for 19-year-olds. Felonies, total felonies were 35. Of that, 19 were big 14. So they would have been filed in criminal court. The remainder, remaining 19, I guess, or so. Anyway, there were 6 youthful offenders and 13 felony charges. But the
New charges in 2024.
new charges in 2020, new felony charges in 2024. Misdemeanors are higher, not surprisingly. Misdemeanors were, the total was 195. Of those, 12 were YO files. There's 9 that say juvenile delinquency. I don't know what that means. You have to go, it's an error of, but you're talking about 113 other than that. So it's, when you look at that misdemeanor filing, think about 30% of those, and these are charges, not people. So you could have one person who had multiples of these charges. Think again about how 30 to 40% of those are going to go off to diversion, and the court's probably never going to see them. They were charged, but then they were diverted. So I'm looking at those numbers and I'm saying those numbers are high, but they're not super high. They're not, especially when you spread them all out all over the state.
And presumably spread them out over time as well.
There are 152 pending. So those 152 could have been filed within the last year. They could have been filed 2 years ago. There could be one that's 3 years old. You know, who knows why those 152, those, you could have a probation violation that's in that 152. So unless you see a breakdown of what that 152 actually is, I don't think you know kind of what the work level that's associated. But to think that 152 cases means that every one of those 152 are going to end up on DCF's probation caseload is, in my judgment, an error. Again, it's cases, it's not people, but even more so, I doubt seriously whether all those 152 would rise to the level of a case that needs to go on probation.
Right. Jack, the question.
Thank you, Chair. Nice to see you again, Judge Davenport. Just a question on the conversation, and this is your earlier point, so I guess it's more a follow-up on the shift from delay to repeal implementation of raise the age. I'm just curious from your perspective, what do you think is the catalyst in the shift in that conversation?
The shift of the conversation.
That now that we're hearing more about repeal instead of delay.
Yeah, I don't understand it, frankly.
Do you think it's the political climate? Or?
I don't know. I don't know why we would repeal at this point. I have not, and I have listened to a lot of the testimony that you've listened to. I've heard some anecdotal stories. I've heard some anecdotal stories, for example, of DCF workers who struggle with 18 and 19-year-olds.
Sure.
I'm not surprised. 18 and 19-year-olds are not easy.
Right.
Any of us who have raised 18 and 19-year-olds know that, right? But that said, that's really anecdotal. And it's and maybe caseworkers need a whole lot more training. Maybe the approach to 18 and 19-year-olds needs to be different. And we found that to be true when we had Bennington. Remember, I talked about domestic violence, developing a domestic violence program for the 18 and 19-year-olds. And when we had Bennington College look at what works for 18 and 19-year-olds is not exactly the same as what worked for a 12-year-old or what would work for a 25, 30-year-old. So, maybe there's more resources that need to be put into training as well. But
no one instance that you think is contributing to this, or a series of instances.
I can't think of that. I can't think of any.
Sure.
On the issue that has popped up the most probably is accountability. So I would second Marshall's thought about looking at the ceilings for cases in the family division. That's in say 5103C2, which basically sets a ceiling for how long
Got an
the,
audio problem.
Okay, all right, we'll have to hold for 1 second, sorry.
It seems. You check the live stream.
Do you want us to
Do
speak?
you want us to talk so you know if we're talking? Is it working?
Hi, Nate. Can you hear us?
Testing 1, 2, 3. Hello, testing 1, 2, 3. Do you hear us? Is audio working?
I can hear you.
Oh, proceed. No?
Yeah.
We're good? Yeah. All right, proceed.
okay, so I mentioned the ceiling in terms of the jurisdiction for DCF over a juvenile. And you'll remember Lindy talking about how at age 20 and a half, she loses jurisdiction. So it's really easy for the 18-year-old who maybe didn't get to DCF until maybe they came into the system when they were 18 and a half or 18 and 3/4, and then they're 19, and that 20 and a half birthday all of a sudden looks like, it's come up pretty soon. I'll just sit and do nothing. So maybe looking at extending those, as Marshall said, other states have done that. That is not something, I should be clear on the record, that I've talked to the council about, but it just happened to come up in testimony. The other thing is, I did hear testimony that the YO system could take care of those 19-year-olds. We don't need to have them in juvenile court jurisdiction because the YO system can take care of them. The YO system is not going to take care of them. You've got a problem with confidentiality. Yes, the state's attorney could file directly, but then you're going to have a problem of geographic inequity, because we know that in some counties that direct filing is done much more than it is in others. I don't think if the case is filed initially in criminal court, even if it goes to the family court for a YO to determine whether they're eligible for youthful offender, that person's name is already in the newspaper. Think about the 12-year-old in Addison County. Her name was in the newspaper. Everybody stipulated after, the blow up and the hearings and everything else. Oh yeah, she belongs as a youthful offender in the family division, but her name was in the newspaper and is searchable by anybody. So I have concerns that is uneasy, that is just not as easy as sometimes it's made to sound. And then the delay that's caused by the ping pong effect. I'm sorry that's going to take till December before you get a proposal on that. It seems to me it's a really easy fix, but again, I'm not talking for the council because this is a level of detail that they haven't done.
If it's an easy fix and everybody agrees that it's an easy fix, we can.
There are people who don't agree that to the fix that would be an easy fix. But the easy fix is basically to have you determining whether or not a felony case should be transferred up to the criminal division, and determining whether that case should then be treated as a YO, are decisions that both of which are made in the family division. And if the family division judge had the ability, when they were determining whether or not the case should be waived up, should go to criminal, to also consider whether this should be a youthful offender, you have overlapping criteria.
Right.
You could do it all in one hearing.
So who's opposed to that?
I don't know. I don't know.
General's opposed to that, Marshall?
No, and in fact, we have a proposal that Judge Zone has, but I guess it's not, I thought it was supposed to be for this session, but I guess it's for next December.
There was a,
But
yeah,
it's already been written up. There's already a proposal that basically combines all of these hearings into one and takes all the differing criteria, combines them into one big list and says judges should consider all the criteria in all cases. And
Just make the decision one or the other.
we may look at that language before December, or I mean, before next year.
I know that language exists. And that's,
Okay, all right, I noted that.
Happy to answer any questions.
Okay, any questions? So just one other thing, I mean, you talked a little bit about accountability, you talked about, the ceilings, moving those up. So beyond that, I mean, the two big issues we keep on hearing, resources are one and accountability is another. And on the accountability factor from Chief Burke, it's like what he called the backstop. I mean, and it was good testimony certainly from Marshall Paul talking about the accountability that there's actually more in many respects in the juvenile system, but there isn't that final, you're going to be detained. It shouldn't be used very often, but that's not available. And any comment on that?
It's the stick, right? When you talk about the carrot and stick approach, the stick for a YO is that you're going to be sent back to adult court.
Right. We don't have that.
You don't have that stick, but you do have, you do have, I think, as Marshall talked about, a case plan, a lot more work that has gone into a case plan for the juvenile offender that's more likely to lead to rehabilitation over the long term. So yes, you don't have that big stick, but be careful of big sticks because I think as Marshall testified to last week, he hesitates to get youthful offender status because that stick is so big.
Right.
And because, a deferred sentence in criminal would be better. Well, it might be better for the moment, but it might not be better over the long term. Because there's no predictability. If you're a YO and you get sent back to the criminal court, you're going straight to sentencing and it's open sentencing. There's no predictability in terms of what you might receive, whether it would be a 6-month sentence, a 5-year sentence. It could be depending on what the maximum penalty is for that particular offense. It's wide open.
I appreciate that. Thank you.
And Judge, good to see you.
Nice to see you too, Coach. I missed you last week.
I was watching this. So a youthful offender and having the victim's testimony, or actually either juvenile, at that sentencing point, and the victim has the opportunity to make a statement.
Right.
That could be pretty impactful.
Hugely, depending. Yeah, I had some cases where that was not a lot, frankly, but where I had a victim who was just incredibly articulate. The one that sticks out in my memory is one where it was a purse snatching. And the victim, a woman in her mid-50s, she just got up and talked to the juvenile about how it had impacted her life and how scared it had made her to even walk down the street because of her fear that someone was going to come and grab her purse. It was so articulate. It was just like, and just watching that juvenile's face, it was, I could see that he was listening to every single word because he'd never thought of it that way, right? He'd gone and done this thing, but he'd never really thought about what are I never probably even occurred to him that there would be long-term consequences that you would be afraid to go in your house, to walk down the street, to that there'd be somebody working. So, you know, it can be really good.
And the last question.
Okay, and I think hopefully it'll be quick. Nice to see you. So these cases, the 19-year-olds, the numbers you just presented us with, I'm just thinking about it, it's not even new cases, it's having to go from one court to a different court, right? So it's not adding new numbers to the court backlog.
Right, right. It is shifting cases from one court to another court. Exactly.
And if DOC is the overseer of these 19-year-olds, and they were about to have a reduction of whatever that number is when we take the number of charges and convert that to people. You were on Ways and Means. I don't know. Is it reasonable to be like, we're going to shift 2 FTEs from DOC to staff these when, or what? I mean, like, I know state government works in
Yeah.
funny ways.
Well, yeah,
I'm just wondering
that's,
about
that's logical, but not necessarily probable. I think, I remember a lot of conversations actually when the 18-year-old, when we were doing the original, raise the age and the 18-year-olds were coming in, there were a lot of conversations, well, could we shift? This is going to take workload away from DOC, put additional workload on, couldn't we shift some? And I don't think that ever happened.
But the problem is DOC is really hurting for staff.
Yeah.
As well. So, yeah, can't
Rob Peter.
shift it around.
And they'll always tell you that they're hurting the staff because they probably always are, but it's not.
Is it?
When was the last time somebody came in and said, oh gee, we have too many staff, take some away from us?
I really appreciate the testimony. Before we break, just a couple quick things. So I got an email from Jennifer Pullman, just wanted to make clear that victims in delinquencies involving listed crimes are afforded the same rights in statute as those in YO matters based upon changes that we made in 2022 as reflected in Act 160. I think that may not have been clear from some other testimony. I just wanted to make that clear. And we have a follow-up testimony that's been posted from Tim Leaders-Dumont that he's addressing some of the questions that came up. So that'll be online. So we will adjourn until 1 o'clock.